Hello, everybody. It is Dean Z speaking to you from Jeffries Hall at the University of Michigan Law School. This is the room where everybody checks in for their very first day of law school, or orientation, actually. So this is where the magic all happens. So I love this room. It's full of good memories for me. Anyway, let's get started. I want to do an episode today that I kind of can't believe I didn't do before because it's such an obvious one. I'm thinking of it as defining our terms. There's so much jargon that we use in law schools and in law school admissions that I never think to define. And I don't know, it finally occurred to me I should be defining it. So I have, for inspiration, I have pulled on my own lack of knowledge that I can remember when I first came to law school, and also asked a couple of friends around here who are first-gen professionals, or actually first-gen college, and I'll just say, if you are first-gen, I'm sure you feel like, oh, there's a whole lot of things I won't know, and that's probably true, and so that's one of the reasons to do this. But I will also just say, I am the opposite of first-gen. Both of my parents were lawyers, and yet there was a whole lot that I was ignorant about too. So, proceed with confidence, okay? All right, let's get started. First one, good place to start. What do we call law students? We call first-year law students 1Ls, 1 for first, L for law. Why do we do that? I don't know. Med school says M1. I think L1 sounds weird, so I guess it's good I became a lawyer, but that's what a 1L is. It's nothing special. It just means a first-year law student. 2L and 3L, second and third-year law students. There you go. While I'm thinking about law students, though, I should also say what an LLM and an SJD are. LLMs it's a Master of Laws, so it's LL for multiple laws, M for master, and that's usually someone who has gotten a legal degree or legal qualification, usually in another country, but sometimes in the United States, and going back for more graduate work. And then an SJD is a Doctor of Juridical Science, and that's basically a PhD in law. And I guess those are people who just really love studying. So not a lot of those in the world. And usually those are people also from abroad who want to study US law in depth. Okay. What next? How about a couple special law school terminology? Clinics. I talk about clinics all the time when I'm recruiting, and it never really occurs to me to question whether anyone knows what a clinic is. And I'm sure that there are a lot of people who don't, or maybe only know part of it. So let's talk about that. Clinics are, within the law school setting, it's a class that you take, you get credit for it, and it's under the supervision of a faculty member, but you are basically operating as a lawyer. You are dealing with clients firsthand, you are going into court, you are negotiating if it's a more transactional kind of clinic, you are acting for all intents and purposes as a lawyer. And so it's experiential, you're getting experience, you are doing something hands-on. So it's a different kind of class than what we call doctrinal classes, which are the classes where you're sitting in a classroom and having a back and forth with the professor and all your classmates. And for the clients, those are usually members of the community. I mean, in theory, it could be anyone in the nation, I guess, depending on the way the clinic is structured, but usually it's from the surrounding communities. So that's what a clinic is. I always sort of picture a clinic as being a medical clinic, and of course, this is not that. There will be no blood involved. Hopefully. Okay, LRAP. That's one we throw around a lot. It stands for Loan Repayment Assistance Program. There are some law schools, not all law schools, but some law schools have a program that will basically help you pay back your loans if you go into some kind of job. And each law school will define this in a different way. Some schools, at Michigan, we just say if you make below a certain income, you qualify for our LRAP, or what we call a debt management program. Same idea. Some schools might say you have to be a certain kind of public interest lawyer. Some schools might say you don't even have to practice law. So that will vary, but it's basically after you graduate, they will help you pay back your loans in some way. So check that out, because that's a great benefit if you go to a school that has one of those. So now I feel like that's a nice segue into legal practice. I think the term that I hear thrown around the most, that I went a long time just really hating the sound of it, but I think it is a useful shorthand, and I've given up and I use it myself. And that is big law. If you are using any of the discussion forums online, you've seen people talk about big law a lot. So what is big law? It just means it's a private sector law firm that is of a certain size, namely big. How do you define big? Well, there are a number of different lists in this world that will define it in different ways and will rank law firms in different ways. There's the Vault 100, there's the American Lawyer or AmLaw 100, there's the National Law Journal or NLJ 250. So there are a lot of different ways you can slice and dice this, but basically it means you got a whole lot of lawyers in an office. Sometimes, mostly, they have different offices. So it maybe is a New York firm with an office in Detroit, or what have you. You're still working for big law, even if it is technically a small office. So I worked for a small Detroit office of a big Philadelphia firm. So I was in big law, even though there were only like 35 lawyers in the office when I worked there. While we're in the law firm world, let's talk about partners, associates, and of counsel. Associates are what you are as you enter law school. As you enter your law firm, you'll be an associate, sort of entry-level position. That could go on for between 4 and 10 years, depending on the jurisdiction you're in and what firm you're in, after which then you may or may not be promoted to partner. And there are usually 2 kinds of partners, at least in the big law world. One kind of partner is an equity partner, someone who has an actual ownership stake in the firm, and that's like the highest level. And then there are sort of a junior level partner, where you don't have an equity interest, at least not yet, but you get that designation as sort of an expression of confidence that someday they will invite you to become a real life partner. And then there's of counsel, which are people who are not on a partnership track, not heading to partners, but no longer associates. They're fairly senior. Maybe they went and did something else and then came back to a firm later in life, or maybe they just don't want to be partner track and want to work fewer hours or what have you. There's a number of different reasons why someone might end up being of counsel. So it's not a short-term kind of thing. It's the idea is that you will be there for a while, but you aren't on a track to something else. It's an end in and of itself. Oh, in-house counsel, that's a good one. In-house counsel are people who work for corporations as lawyers. You are in the corporate house, if you will. How about public interest? People ask all the time about public interest. I want to do public interest law. What does Michigan do for me? I think of public interest as meaning that you are working for a nonprofit organization, and not government. Although public defenders are usually government employees, almost always as far as I know, but I think of them as more public interest because you're not working for the man, you're working for the clients. So your public interest is, you are working for clients in the interest of the public, however you may define that. You could, in theory, have 2 public interest organizations that are on opposite sides of a lawsuit, so it doesn't suggest anything in terms of what your point of view is. It just means you are operating what you think is the interest of the public. Public service, on the other hand, usually denotes government work. You are specifically working for the government. You are in the service of the public. The public is paying you. Another terminology from inside law school that might be useful are law reviews and law journals. In law, the most prestigious publications for the industry, the legal industry, are student-run, which is very unusual. And odd, frankly. Why are students playing this very important role for the industry? I don't know what the history of that is, but that's how it is. So, as far as I know, all law schools have at least one law journal or law review. Usually, the premier, if you have multiple journals, usually the premier journal is called Law Review, although not always. At Yale, the premier journal is called the Yale Law Journal. But usually it's just sort of a general name like that, Law Review or Law Journal. It doesn't have any other descriptor. Many law schools have journals that are more narrowly tailored, that have a specific set of interests that they are addressing. So at Michigan, we have an international law journal, a gender and law journal, a race and law journal, a technology law journal, on and on. So many journals. And many other law schools have that as well. The difference between those journals usually and the sort of the premier journal is one, that the premier journal is general interest. It takes topics, all kinds of topics, but also it tends to publish more, it tends to demand more work of the students, and for that reason, it tends to be more prestigious and harder to get on. The ways you get on a journal, and that's usually for your second and third year in law school, not your first year. Again, exceptions to that. This is just the general rule. The students will come up with whatever system they want to come up with for how you get on a journal, but sometimes grades are involved, sometimes writing samples are involved, what have you. But there is this difference between, like I say, the standard general premier journal and then the sub-journals, if you will, with different specific topics. And I think that's worth knowing. As I mentioned at the outset, I'm the daughter of two lawyers. I had no idea that there's any difference among these journals or between these journals in terms of the importance attached to them by future employers. And there is. The Law Review, the main one, is viewed as a bigger feather in your cap than the other ones. I only applied to the International Journal because that's the one that seemed most interesting to me, and I had no idea there was any difference. Now, I think I made the right decision for myself in being on that journal. I didn't want to spend all my time just doing journal work, which is basically what happens if you are on the main Law Review. I wanted to do other things too. But it is irritating to me in retrospect that I had no idea that there was a difference when I was applying for those journals. So, you know, it's nice to be fully informed. Now you can make your decision. I now want to turn for the next stuff. I think I've run through all the ones that I thought of, and I now want to turn to the ones I got from friends around here. So Moot Court, that's a really good one. That's an activity that we do in law school. I find it confusingly named because in American law, if something is moot, it means it is no longer an active issue. We don't need to talk about it. But Moot Court is a simulated oral argument, or maybe even a trial, where you as a student are pretending, if you will, to be a lawyer in an active case. It's a fake case. We give you a fake set of facts, a fake set of materials, and then you go ahead and argue about it. So it's sort of the opposite of what the word moot means in American law, because you're arguing, whereas moot means there's nothing left to argue about. So don't ask me to explain the whys. I'm just telling you the whats. But that's what Moot Court is. It tends to be, it's just sort of an extracurricular activity in most law schools. Okay. I love this one. Civ Pro. We have all kinds of shortenings of class names in law school. So Civ Pro is short for civil procedure. The person who told me this was something he didn't understand said that he thought it was, people were saying Cipro or Civro, or as it once showed up on one of our videos with the underscoring, it was Sith Pro, like the Star Wars villains. But it's Civ Pro, and Con Law for constitutional law, and Fed courts instead of federal courts. We're very, very busy in law school. We can't possibly say all the syllables, so we got to shorten things, you know? What else? Here's a good one. Hornbook, Casebook, Blue Book. What's with all these different kinds of books? A casebook is the name for your standard textbook. It has shortened, abbreviated cases in them and some questions that follow, and that's your principal thing that you're going to use in classrooms. Hornbook, on the other hand, is sort of like the idea of a Cliff Notes. It's explaining everything in the casebook, only it's not Cliff Notes because it's like at least as long as the casebook, often longer and more in depth. So it is. It's like the explainer. You don't necessarily ever need to use a Hornbook, but they can be handy. They're nice if you want to really dig deep on something. And then Blue Books, you might know them. I don't know if people still use blue books in exams in college, but where you write out your exams in a blue book. That is not the blue book we are thinking of. The blue book in law is a citation manual for showing you the format for how you cite cases or journal articles or all the different things that you might cite in a legal document. There's a certain kind of standard that you should use, and that is all laid out in the blue book, and it's amazingly thick because that's the kind of thing lawyers really enjoy making rules about. And it sometimes gets used as a verb. So you might say, I was blue booking, or I just blue booked that. So it means checking the citations and making sure the formatting is all correct. So you can throw that around if you want to sound like you really know what you're talking about. Few last ones, because I feel like I've been going on. I could go on forever, literally. But let's wrap it up. Okay, here's one. Why is contract a K? That came from a friend. And what he's talking about is when you take notes in your class, or if you're in a hearing or whatever, and you're taking notes by hand, you're going to want to abbreviate things, right? You can't be writing out the word contracts if you're going really fast. For some reason, we abbreviate contracts as K instead of C. I don't know why. And in preparation for this, I thought I'd Google, like, why? Just out of curiosity. I said I don't really tell you the whys, I tell you the whats. But I found this 2021 article in the Minnesota Law Review spelling out K is for contract. Why is it though? And it's hilarious. Just like Supreme Court justices, law students in the US almost unanimously abbreviate the word contract using the capital letter K. Despite this consensus, no writer has ever explained why a word that starts with C should be abbreviated to K. Instead, the present paper investigates this question following threads of legal discourse, yada, yada, yada. I mean, you could go deep on this if you want, so you might want to check that out. We do a lot of other abbreviating in law school notes, but I think I'm going to just leave that with K for now. And now, finally, because I think this is a catch-all that could be its own episode, any Latin word. That came to me from a friend, but particularly pro bono and pro se. So I'll briefly define those, even though there are a lot of Latin phrases that get thrown around in law school. Pro bono is actually shorthand for pro bono publico, which means for the good of the public. And that means whenever you're basically taking a case and not getting paid for it because you think it is for the public good, you're doing it pro bono. And then pro se is when a non-lawyer is representing themselves in court. So prisoners, for example, often file pro se civil rights actions against the prisons where they are being held for various violations of their civil rights. Alleged violations of their civil rights. I should be careful, right? Yeah, so that's what pro se is. But now, here's how I'm going to wind up this episode, because the same person said, I had also never heard the term carte blanche until my 1L oral argument and was being asked by the judge whether I was arguing for carte blanche authority. That was embarrassing. So carte blanche means a blank paper. It's actually a French term, not a Latin term. And it just goes to show you're always going to have things that you don't know. Like, even if some well-intentioned person, like I am making videos about terminology, I would never have thought of carte blanche. And so you have to do two things when you're entering this world of law. You first of all just have to be comfortable with, even if you are super experienced, even if you've been working as a paralegal for 20 years before you get to law school, I guarantee you there are going to be terms that you don't know or that are being used in ways you've never heard. And you have to get comfortable with stopping the person and saying, like, hang on, I don't think I know that. Can you explain that to me? There's no shame in that. Just do that. Own it, right? Or, we all have phones in our pocket now, and you can Google it if you can figure out that it's Civ Pro that someone's saying and not Sith Pro. But yeah, so don't be embarrassed about not knowing things. Just ask. And if someone is a jerk about explaining it to you, well, that's on them, not you. All right. That's all I got for that. Now let's turn to the language part, even though we've just spent an entire episode on language. Here is what I want to say. I went to the ATM machine and I entered my PIN number and I took the cash and put it in my safety deposit box. Can you spot the problem in that sentence? There are 3 problems in that sentence. That was a trick question. Problems are this. ATM machine? No, ATM stands for automated teller machine. So if you say ATM machine, you're saying ATM machine. You're just repeating yourself. Same with PIN. That's personal identification number. So don't say PIN number. And then finally, safety deposit box. That's a different kind of error. It should be safe deposit, not safety. You are depositing something and making it safe. Why do I care about this? Because Mr. Dean Z cares about this. He was a prosecutor, a federal fraud prosecutor for his legal career. And so he had to think a lot about ATMs and PINs and safe deposit boxes. And he just really is upset when people get that terminology wrong. So, you know, if you meet him, maybe be careful. That's all. All right. I think that's enough for today. Thanks, as always, to Dustin, who is here despite having massive amounts of illness in his household. So extra thanks to you. And thank you all for listening or watching. If you have any comments, please leave them below, including ideas for other terms that I should define, or send an email to us at law.jd.admissions@umich.edu. Put vlog in the subject line. And wherever you go, go blue.